Hi, I'm Ruth Hosking. I'm a barrister at Quadrant Chambers and I specialise in commercial law. And this QBiT talk is called What Are Sanctions? So what are they? Well, in broad terms, sanctions are restrictive measures that can be put in place for a range of purposes. They can be applied to diplomatic, to economic and to cultural relations between states, and they're usually used to try and stop certain behaviour of particular states which other states think is unacceptable. They can be imposed by one state against another. That would be a unilateral sanction. They can be imposed by an international organisation such as the United Nations or the EU. That is a collective sanction. Often, sanctions will be done by multiple states individually at the same time and by organisations such as the EU. Now, one of the issues that then arises is harmonisation, because no two sanctions regimes are the same. And it can be really difficult for businesses, particularly compliance officers, and for lawyers to know which regime applies and how to apply it. Now, why does that matter? Well, the difficulty is if you breach a sanction, you are subject to a sanction yourself. So there are potentially legal consequences for a failure to comply with sanctions, and we'll discuss those a little later at the end. There's also a difficulty if it's in the public domain that your failure to comply with a sanction is there, because there are reputational issues for clients. There are different ways of categorising sanctions. There are lots of ways of doing it. The way that the United Kingdom government does it is by definitions of 4 types of sanctions. The first are trade sanctions, so that would include things like arms embargoes. The second are financial sanctions, so that would include things like asset freezes. The third are immigration sanctions, so things like travel bans. And the fourth are a slightly longer category, such as aircraft and shipping sanctions, which include, for example, deregistering ships or controlling the movement of aircraft and ships. Now, it's understandable why the UK government does it in that way, because they're all dealt with by different departments that tally to the type of sanction it is. But from a commercial law perspective, it's much better, I think, to think of sanctions by 3 broad categories. The first is geographic, the second are people and businesses, and the third is sectoral. So what do we mean by that? Well, a geographic sanction, for example, would be a blanket prohibition on exporting goods to a particular country or to be used in a particular country. So some examples would be a ban on exporting luxury goods to Russia, a ban on exporting sterling to Russia, or a ban on exporting any goods at all to North Korea. Business and people as the basis of a sanction. So peoples are just individuals named on the sanction list, and businesses are simply entities that have been named on a sanctions list. Perhaps more difficult to understand are the sectoral sanctions. So for example, you might have a ban on a particular sector. It might be shipping, it might be aviation, or it might be energy. So let's consider one of those. An example, a prohibition to UK ports to provide access to any ship which they have reason to believe is registered to a Russian, is flying the Russian flag, or is owned, controlled, chartered or operated by a designated person, i.e. someone on a sanctions list, or owned, controlled, chartered or operated by any person connected with Russia. So why is that difficult? Well, the very nature of ship ownership, which is often through a special purpose vehicle for a single ship, which is registered in various places around the world, normally those without a transparent record, makes it very difficult to unravel. Similarly, chartering arrangements. How on earth do you know who the slot charterers are? So those are the sorts of things that can make it really difficult to work out whether you've breached a sanction or not. So let's have a think about the framework in the UK. So the framework in the UK is that you have an umbrella legislation at the top, which is the Sanctions and Anti-Money Laundering Act of 2018. And then underneath that sit the individual sanctions that are done from time to time. So an example of that would, for example, be the Russian Sanctions EU Exit Regulations of 2019. And then underneath that, you get regular updates and amendments to those regulations as things move forward. So let's take an example to make it real. Just so that we know, a designated person is essentially a person or a business that appears on a sanctions list, and that gets updated all the time. So let's use the Russian sanctions. Regulation 11 of the Russian sanctions originally provided in 2 parts. It firstly provided that a person must not deal with funds or economic resources owned, held or controlled by a designated person. And then it provided if you knew or had reasonable cause to suspect that you were dealing with such funds or economic resources. So there was essentially a due diligence element, but that left in mid-June 2022, and essentially it became one of strict liability. Breach of a sanction was committed simply where a person dealt with funds or economic resources, even if they did not know or had reasonable cause to know that that's what they were doing. It's really important to understand what is meant by control, because in all sanctions regimes, whether they be in the United Kingdom or the USA or in the EU, they all talk about control. So let's take our Russian regulations as an example. Regulation 7 subsection 2 talks about control being assessed by reference to direct or indirect control of shares, voting rights, or the board of directors. So it essentially has a 50% rule. So if a person directly or indirectly holds more than 50% of shares in equity, or 50% of the voting rights, or they have the ability to remove or appoint the majority of the board, that is enough for control. So if the individual is sanctioned, therefore the entity with which they have that control is also sanctioned. That is essentially the same as what the US do. So under OFAC, they also have a 50% rule. The only difference is that in the US, you can take 2 sanctioned people and combine their aggregate. So as long as that is over 50%, then the whole company is also on the sanctions list. What's different in the United Kingdom, certainly under the Russian regulations, is that there is an alternative test which gets much trickier, because it essentially is whether you're in de facto control, although you have no legal control. And there is an example of this in Usmanov, who was the Russian mining and telecoms oligarch, who was the former major shareholder of Arsenal Football Club and was once said to be the UK's richest man. He was put on the sanctions list in 2022. And at that time, his spokesman told one of the newspapers the following: "Most of the billionaire's UK properties, as well as his yacht, have for a long time been transferred under an irrevocable trust. From that point on, he did not own them, he did not manage them or deal with them for sale, but he could use them on a rental basis. He withdrew from the beneficiaries of the trust and donated his beneficial rights to the family." Now, an interesting question, and one that's not yet been grappled with, is whether that would fall essentially under a sort of de facto control. Could he, or someone in his position, control his property, his yacht, and everything else because he had control over his family? And so that's where it gets quite interesting. I said at the beginning, why does it matter? And it's because you can have sanctions for breaching sanctions. So in the United Kingdom, there is an office called the Financial Sanctions Implementation Authority. And what can they do? Well, there are 4 remedies that they have. Starting from the one end of the scale is warnings and referral, and up the other end is criminal prosecution. So a warning or referral might just be issuing correspondence, asking a particular person or a firm how they're going to improve their compliance in the future. Or they might report you to your regulator if you have one. Or they might report you to an overseas regulator if they think that those sanctions abroad have also been broken. So that's first, warnings and referrals. The second is publicity. So even if they don't give you a monetary fine or seek to prosecute you, they can publish a report that goes out into the public that says you've been very badly behaved and you've breached the sanction. Most companies do not want that. And then as we move up the end of the scale, we get monetary penalties, and those vary over time, and it depends on what regulation you're looking at. But it's important to remember that a monetary penalty can be imposed both on the legal entity and separately on the officers who run it. So it's not small change, and it's something that insurance is often needed to try and deal with. And right at the other end of the scale, there's criminal prosecution. So the OFSI can refer cases to law enforcement for criminal investigation, for potential prosecution with possible prison sentences and fines, although sometimes you can have a deferred prosecution agreement for financial sanctions offences only. And on that very happy note, that is Sanctions in 10 minutes.